Please. Who do we have here, Greg?
This is Mr. Zenon, Your Honor.
Visit PC, Your Honor. I have some questions.
Oh, you picked up a new case. I'm sorry, I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Yeah, him. He picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case.
Whoa, pause for effect. This man's rap sheet is long enough to qualify as a mini-series. 10 cases in 2.5 years? At this point, even the judge sounds like she's got courtroom deja vu. Question for the audience. How much trouble does it take before probation just isn't on the table anymore?
Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case. Specifically, an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, a felony possession of marijuana.
You can hear the judge trying not to sigh through the bench. It's like she's reading off a CVS receipt of criminal charges. But here's where things start getting murky. If all those cases were dismissed, how do they still carry so much courtroom weight? Let's break that down later, but keep listening for the twist.
Felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading, and now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess,
I understand.
that we literally had one after the other, like a rung on a step ladder. One after the other. So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate it, Your Honor.
Sure.
But be that as it may,
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd of 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed what?
located. They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana.
This is a major shift for 911. Calls, physical aggression, a threat to slap, and resisting arrest. Whether or not he meant it in legal terms, that's probable cause gold. But hold up, does a threat alone justify arrest? Let me know in the comments. Would you call that enough to cuff someone?
The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW And another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon
But he has an open ag assault somewhere else too?
in Fort Bend County, Judge.
My understanding is it's an
It was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're a 0.1 mile away from the location. For what?
Well, okay, I get that, but so we've got a disturbance at HEB. Cops go there,
Okay.
They start to talk to him, and I guess at that point says, hey man, I'm gonna slap her. So at that point, I mean, that's what we have,
Okay.
right? Mr. Zenon,
Okay, legal nerd moment. This is where interpretation meets chaos. The law says interrupts, disrupts, impedes. And honestly, that's broad enough to charge someone for sneezing during an arrest. Judges and lawyers know it's big. But is that vagueness protecting officers or creating loopholes?
there's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
No, it's the aggravated assault, but Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes blank like this for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because I mean, there's no better way. Let's read it.
Hold on.
I'll give you. All right. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly they could have
Okay.
taken a whole myriad of. I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on. You know, if
they didn't hit. They took the one that I do not believe applies here.
let's read the code. Let's see what the code says, because you know there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can. It's 3815.
That's okay, don't worry.
You're right. It could have been like a resisting, you know, but. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, So I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so
that.
that the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute. That's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1
It's an
miles
open
away.
felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what or the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like, and that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I mean, that's what they were investigating.
And the witnesses all described
They put him,
the
I guess, did they put him under arrest at the time when he said that he was making that threat?
And with being
I mean,
0.1.
did they have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap the misclaim.
And it's at that point they start to put him under
At
arrest?
that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Crucial clarification here. Probable cause is not guilt. It's the legal version of saying, this smells fishy enough to investigate. But what do you think? Based on what we've heard so far, does this sound like interference? Or just a frustrated guy going limp in a cop car?
Okay, then that's a resisting from what they're using to say he's pushing back or pushing.
Remember,
That's
I
a
mean,
resist.
it-
That's not interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. It's the officer didn't put in the report. He's not saying in the dim summary, you are under arrest.
We don't.
Well, I mean, it's
Okay, well, I mean, but
we don't know. I mean,
Okay, I'm just saying.
if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also don't have the offense report
We
yet,
don't
I
Judge.
don't
That's
care. I
what-
mean,
he was in
but
the
I think that
process.
there's enough, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
I see that, but I don't have the.
I
I've
mean, I
shared the
think that-
videos with
Remember,
You're right, I haven't had a chance.
guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, Beyond a reasonable doubt is a different standard. This is just to see if there's enough.
Whoa, pause right there. Did you catch that pivot? The judge just went from open ears to, we have probable cause real quick. Legal takeaway, probable cause isn't guilt. It just means there's enough smoke to investigate a fire. But don't confuse it with proof beyond a reasonable doubt.
To go forward. And according to this, you are disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way.
That's courtroom gold right there. When a judge starts talking halos and prison time, you know it's real. Probation isn't a free pass. It's your one shot to stay out of prison. So why risk it for chaos and cuff clicks?
Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I gotta say,
required 3 times to search me.
can I have a moment to look at the video? Here? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now.